right, we are live. Thank you, sir. All right. Welcome back, everyone, at 11:15-ish. We are going to have an introduction walkthrough witness testimony on H697, an act relating to first responders buffers during ongoing public safety emergencies. We'll start off with Representative Oliver, who is the sponsor of the bill. Then we will speak with council, and we have Representative one across the street for General Order of Police. Representative Oliver, good to see you, sir. The table is yours.
Sure. And thanks for having us and introducing our bill. It's a bill that I think has had a sort of a need for quite a long time. I came up with it this summer after seeing some more incidents in the Chittenden County area. I go back almost 40 years in law enforcement. I think the first time I've had an incident where this could have been useful was maybe my first 5 years. You know, somebody jumps on my back when I was arresting somebody else and they were not involved in the situation. But it's not just germane to law enforcement, it's germane to firefighters, EMS. It's just something that officers, EMS, first responders can deliver, I believe, a better quality of work when they're not distracted by other things. And as you know, whenever we're involved in something, it can draw a crowd. And that crowd can be nice. It can be not nice, adversarial, and there could be people there just wanting to film. But it's very important for us to have space, a curtilage or perimeter, if you will, that we can do our job. And I brought, I'm going to hand it off right now, actually, to Mr. Coral from the FOP to go over the bill or talk about it, or after the introduction, whichever. He's going to be the go-to witness.
Understood.
Thank you very much.
Yeah, I think I would want to go with Tim first. It's, really just 2 pages of language to run through, so we should be able to do that reasonably briskly. Council, how are you today, sir?
Doing well. Thank you very much for having me, Chair Byron and committee members. For the record, my name is Tim Devlin, Legislative Counsel. We have before you, as introduced, H697, act relating to first responders buffers during ongoing public safety emergencies. And you're correct, it is indeed a pretty brief bill. The substance is in B2, the definitions are in A, and I figure maybe it'd just be helpful to run through the kind of mechanic part of it first, and then kind of get back into the definitions as we can term. So let's see. I'll just quickly read through this and then go back through it again, detailing various items worth the committee's particular attention, if that's okay. So, subdivision B, halfway through page 2. It is unlawful for a person to intentionally remain or come within 25 feet of the first responder during a public safety emergency. A, after the first responder verbally identifies as a first responder. B, after receiving a verbal warning from the first responder not to approach the first responder. And C, with the intent to 1, obstruct or impede the first responder's ability to perform the first responder's duties. 2, threaten the first responder with physical harm. Or 3, harass the first responder. Then we move on to the penalties in subdivision B2. Person who is convicted of a violation of this section shall be imprisoned not more than 60 days or fined not more than $500 or both. And then this will be effective January 1st of next year. So let's go through that language again with a fine-tooth comb and bouncing back to the definitions. It is unlawful for a person to intentionally remain or come within 25 feet of the first responder during a public safety emergency. First responder is defined in A2, and this is at the bottom of page 1, breaking across page 2. That will include law enforcement officers certified by the Vermont Criminal Justice Council, firefighters, as defined in statute, and emergency medical personnel, as defined in statute. A public safety emergency is in A4, right above B1, halfway through page 2, and means an acute event in which a first responder must engage in the lawful performance of a legal duty to address an immediate threat to public health or safety. So just to note, this is not the same definition as we select at all hazards events. This is very particular and not really to be confused with how we see it in emergency response measures typically throughout Title 20, for the most part.
So this would isolate it more.
Yes, it's not as broad as we typically see.
Yeah.
Public emergencies kind of, but it is still a broad term, and, you know, accounts for immediate threats to public health or safety. So that could be crime. It could be indeed, you know, some sort of natural disaster, man-made disaster, something like that. But importantly, it should be noted that the first responder is engaging in the lawful performance of their legal duty doing it. So two kind of qualifiers there.
With like a vehicle accident or some other type of,
Yep.
scenarios such as that, like I'm just spitball, like I
That
could
would qualify.
say like a construction crane falls off a building.
Sure.
Okay. Rep Stone, then Rep Wise.
I hear you saying it's broad. I just wonder if there's any definition in statute of what a public, like, safety emergency situation is, because it seems rather subjective and like it would be left up to the discretion of the individual, like, responder. Am I correct in that?
Yes, there's a few things in there. There is the Title 20 has a general all hazards event definition, which covers largely large events, everything from a bomb to a flood to radiation, things like that. So if it's that wouldn't be grant itself to kind of replicate it here too easily. It's kind of a different context. It was deemed appropriate to kind of create a new definition from whole cloth for the most part, rather than cross-referencing something already in statute. As far as who interprets it, like any other law, there's kind of a series of decision makers kind of in here, both before, during, and after. So before, what constitutes that immediate threat to public health or safety that would presumably be entailed in training of law enforcement officers, firefighters, and emergency medical personnel as to when this would apply. There is an element of does it apply in the moment as interpreted by the first responders. And then if there is the idea is to be contested after the fact, we see it being interpreted by the judiciary in litigation, possibly, like any other law. Does that answer your question, Stone?
Yes.
Okay. So
I think I had another question. Sure.
Hi, okay, so I am looking while you're talking and it says, so it's anyone who's certified or under the recognized by the Vermont Criminal Justice Council. Does this include sheriffs?
if the sheriff is certified, yes. Just anybody who's responding in an official law enforcement capacity. Sheriffs, just a quirk of our state government, they're constitutional officers and they don't have qualifications for office written into the Constitution. So you don't actually have to be holding a law enforcement officer certificate to be a sheriff. In that case, you'd presumably just be doing the administrative portions of the job. You don't have to be. So this would apply to sheriffs who do have law enforcement officer certification, including their deputies who do as well.
Okay, and would it apply to like ICE agents and border patrol agents?
This is contemplates state law enforcement officers only.
Okay, and then on the other side of people who are subject to this, would reporters and journalists be included in people who can't get within that 25-foot barrier?
It is, let's see. So looking at revisiting the language here, it's unlawful for a person, so that's anybody regardless of profession or any sort of vocational qualifier. But then it's conduct dependent after that. So it's a broad, it's any person, but that person has to, let's see, first be warned or receive a verbal warning, that's B1B. The first responder has to first identify themselves as a first responder, and then with intent, they have to either be obstructing or impeding the performance of the duties or threatening or with physical harm or harassing. And harassing is defined in here as well. And I can turn to that if you want. So it can be applies to anybody so long as they are conducting themselves in one of those categories as defined here.
Okay, so in theory, a law enforcement or a first responder could say that a reporter is causing them substantial emotional distress by taking pictures of an incident or recording an incident, and then that would apply under harassment.
Let's see. So harassment we see defined in 3 here. Sorry, A3, just for the committee's edification, we'll just read out loud. Means to engage purposefully in the course of conduct directed at the first responder that would cause a reasonable person substantial emotional distress, and that is not otherwise legally permitted. So let's flip over to emotional distress quickly, which is A1, which will mean significant mental suffering or distress that may, but does not necessarily require medical or otherwise professional treatment or counseling. So significant mental suffering or distress that is not otherwise legally permitted and then is qualified by a reasonable person standard. So this would be, left to litigation, and the court would decide, okay, does a reasonable person think that taking photos of a police officer, I think it was in your scenario, would that cause the officer significant emotional distress, meaning significant mental suffering or distress? Would be fact dependent, and as written, we leave it up to really ultimately the courts to decide if that's really the case.
Thank you.
So
I'm sorry, it looked like Representative Oliver might want to say something here.
Just regarding that, we put some thought into that. Attorney Devlin picked up on it and automatically put in that rule. Obviously, nobody's going to be measuring anything here. It's going to be, more on a reasonable basis. And we did think that you have to, there's people's First Amendment rights out in public. And we were thinking about reporters when considering this. 25 feet with a camera and a microphone, usually still is pretty effective. We do have instances though where there are folks that come up and try to get into the middle and film an interaction, a very personal interaction that we would like to discourage, but not prevent by putting the distance.
Thank you for that, Representative.
And let's see. Okay, so just returning to this, I'd just like to point out in B1, it is unlawful for a person to intentionally remain or come, et cetera, et cetera. The intentional part is the mens rea or the mindset that is the conduct that. So we have various standards or levels, I should say, of the person's mental state. So we could be intentionally or willfully. It could be something like knowingly. It could be recklessly. It could be negligently. And so we go with the highest standard of the person had to know exactly what they were doing, rather than just kind of they should have known better. Also, I'd like to point out that in B1, so the person has to intentionally remain or come within 25 feet of the first responder during a public emergency. And we skip down to C, with the intent to either obstruct or impede, threaten, or harass. And so the second intent is kind of reading it again. Actually, I guess maybe the first one, there's a choice for the committee to be made, whether they consider that redundant or not. Or I guess there's a world where strictly reading it, the to intentionally come within 25 feet, there's, I guess, possibility that you could unintentionally come within 25 feet if you're corralled or somehow pushed into it. I don't know exactly the likeliness of that, or but I would defer to the witnesses to really kind of speak to if there's any other situational or meaning there to be granted to that, or if it is truly redundant, we just kind of leave it in C and remove it from B1. Or if there's harm in the opinion of the committee, leave it as is too. It's up to your discretion. Let's see, what other definition I've spoken to? I think that's everything actually. And then I would just note there's typo in one of the commas and the definition of emotional distress. Fix that at a later point. Any questions?
Rep. Waters Evans, then Representative.
Yeah, so going back to where it says it's page 2, line 6.
Yes.
Defining a public safety emergency. Is this an event, or is this definition something that appears elsewhere in statute, or is it created specifically for this?
Pretty specifically for this, there are similar definitions elsewhere, mostly in the context of disaster response. Article 20. That's what I was speaking to earlier with the all hazards events. Like that. I can go through other parts of Title 20, specifically Chapter 155, where we have the law enforcement officer certification, the provisions for criminal justice counsel. See if anything comes up there, but I'd have to double check.
Okay.
If there's like, Representative, are you interested in cross-referencing something or?
What I was interested in is it says an acute event in which a first responder must engage in the lawful performance of a legal duty to address an immediate threat to public health or safety. So I was wondering if would, like, someone standing in the street with a gun, yes, that would apply if they were aiming it at a crowd. But would that also apply to someone being pulled over to get a speeding ticket? Does that also account as an acute event where they're performing their legal duty? Like, I'm wondering where the line is or
Sure.
what that means.
Interesting hypothetical. So stop. I'm pulling over something. Let's see. Like everything else, you'll hear me always say very fact dependent. But applying that here, the law to the hypothetical, we would have an acute event. Yep. That would qualify. And then where the first responder is engaging in lawful performance of legal duty, if the pullover, likely for law enforcement purposes, but also, let's see, if it's the car's on fire or something like that, you can involve some of the other first responders, or if it's a wreck, right? And then the legal duties box be checked there. And then to address an immediate threat to public health or safety, that would depend on the nature of the pullover. Was it reckless and drunk driving? That would qualify versus a something more mundane and pedestrian where there wasn't really the risk of flight or something like that. Probably wouldn't qualify for that. Somebody rolling through a stop sign and then immediately pulling over. Probably not. But fact dependent.
Thank you.
Deb Nugent, Pistol Stone, and then I would like to get to Detective Curl.
I was just wondering what recourse law enforcement has right now in these types of situations, or what protections they have.
Recourse protections.
Yeah, either or.
For, let's see. Well, we can kind of take a look at B1C. So there's obstruction of justice or impeding a first responder's ability. again, depending on the nature of obstruction. There are certain laws already on the books about that. Let's see, we have threatening first responder with physical harm. That would fall into just general threats. Like any other person can't commit a threat against them. The target of the threat is largely immaterial. And then harassing, harassing isn't really, in itself, a crime on the books. We have things like stalking, we have things like criminal threatening again, which could be harassing depending on exactly how it rolls out. Let me think. We have certain civil and tort that are somewhat similar. Intentional infliction of emotional distress, for example. Things of that nature, which are not necessarily criminal, but do crop up in other either common law actions or provide for elsewhere in the Vermont statutes annotated. And then similarly, if you're inflicting any sort of harm, emotional or physical, that does result in medical treatment or whether that be psychological or physical, that can be individuals could be held accountable for that as well under existing law. So I would say, just to kind of go on a little bit further, largely the new elements of this are the perimeter feature.
Professional.
As a sister of a fire chief, I cannot tell you how many times he's explained to me how many times he's had to use force or like get away from the scene. There's a bad car accident, cars on fire, the trap people in trap, and those, what do you call those, ambulance chasers are in the way. And he's like get back. And they always want to be like very close. So I can see this not only for police protection, but also for fire. He said he spends more time as the fire chief instead of directing, his firemen want to do something. He's doing crowd control because people just want to keep pictures and that in the way. So I can see where this would help in that kind of thing. And to me, a public safety emergency, when you see sirens and red lights or blue lights or whatever, that's an emergency. So, so I can see where a lot of this would take place. And I get your 25 feet. I'm trying to visualize it's like that wall to that post. Probably 25 feet.
Yes.
That's pretty close. So, and I don't believe there's any protection at this point to stop anybody. Am I right? There's no law that says.
That would be a question for council.
And I apologize, I'm looking into what is obstruction of justice versus the things that kind of, I don't know if that actually would be the exact one. That seems to be more relevant to interfering with kind of ongoing contested cases in the state of Vermont. Although I'd have to get back to you exactly to see. I could check with our judiciary attorneys on it.
And Rep. Stone, do you have a question or no longer see it?
I do. So back to the public safety emergency. This is the original question I asked. Looking at it, it's an acute event which a responder must engage in, blah, blah, blah. It still seems pretty subjective. I'm wondering if there are other states who have passed laws like this, or I'm still concerned that that's pretty vague and subjective. And it seems like I want you to clarify like your answer from before, that it's up, like it would have to go through litigation like after the fact if there was concern that it wasn't in fact like it wasn't in response to like a legal duty to address immediate threat to public's health or safety. Am I right in that? Was I hearing what you said correctly? It just seems like it's subjective in the moment, and the only way to like do anything would be after the fact in a court.
Well, there's a few things there. I know there are other quote unquote halo laws in other states. Florida has one off the top of my head. I have to look into to see exactly what the exact language of that is or what other states may have and what their exact terminology is. The other option, if is to breathe more detail into the definition here, if the committee believes that it's, too vague or doesn't offer up an immediate understanding by either law enforcement officers, member of the public, or really any reader. That's an option for the committee to take. If the words on the page are enacted, yes, any question as to, whatever sort of conduct does fall into this, or really, sorry, not conduct, but whether the circumstances surrounding, somebody being prosecuted under this statute, truly are a public safety emergency, yes, that would be discussed in court, and I'm sure probably one of the issues debated over by prosecutors and defense counsel.
All right, thank you, counsel. Yes, Detective, how are you, sir? Good, thank you. Good to see you. Just introduce yourself for the record, please. And I know you had testimony or a written statement. Did you share that with our committee?
I have not yet, but I can.
Whenever we wrap up, just so we have it. So the table is yours, sir.
Thank you very much. Good morning. Thank you for your time. My name is Joe Coro. I'm the president of the Vermont Fraternal Order of Police State Lodge. I represent 322 law enforcement officers across the state of Vermont. We're part of the Fraternal Order of Police, about a 400,000 member organization. I've been a police officer of the Burlington Police Department for nearly 12 years. I spent my first 9 years assigned to patrol, where I served as a field training officer, continuing to instruct patrol procedures with an emphasis on officer safety tactics. I'm currently assigned to the Detective Services Bureau, specifically in the drug unit. I serve as a team leader on our emergency response unit. I'm also the immediate past president of the Burlington Police Officers Association, FOP Lodge 21. For the majority of my patrol career, I worked the evening shift, 4:45 p.m. to 2:45 a.m. So most of my shifts concluded with bar closing details in the Church Street area, where we manage large crowds and frequent fights from Thursday through Saturday nights. There'd be other nights where we'd have them, but generally Thursday through Saturday, you could expect to be in multiple bar fights throughout the night. Spent many nights breaking up altercations and making arrests in that downtown district. When the police department was fully staffed at about 95 to 105 officers, they were really well managed in the sense that we had enough officers to effect the arrest, deal with subjects, witnesses, and then on top of that, have a good amount of police officers who would create a barrier for us to do our job. So in the past 5 years, what I've seen, both in practice and seeing my other officers actually go through and deal with this stuff, it's way more chaotic than that. We obviously, if you know, we were defunded, refunded. In that time, we had a lot of attrition. We lost 40 officers. We still haven't covered those 40 officers. So you get a lot of times where you have a police officer attempting to deal with subject or witnesses, and at the same time, they have a crowd starting to close in on them who are frustrated. Either they don't agree with the process that's occurring, they don't understand, something is happening, and they want to be involved. To try to deal with that person and deal with those people at the same time is very, very difficult and very dangerous, because it causes it to go from a simple encounter where there may be a use of force that has to occur to place somebody into custody, but now you're talking about dealing with that use of force, possibly another use of force starting, which then heightens that level of force that can occur. And, we could end up in a very tragic situation where you end up with a lethal force situation and a fatality. And we don't want to see that. It just increases the tension, the likelihood that force is going to be used, and creates significant risk for both the public and the officers. And if we can get through every bar close with, minimal uses of force, as well as, people getting hurt, assaulted, so on and so forth, that's our goal. And you asked a good question earlier related to previous laws that we have in the books that we can use and that we do use. The one I'll put out there is impeding public officers. It's 13 VSA 3001. Statute criminalizes hindering an officer acting under authority and includes serious conduct such as removing or depriving an officer of their weapon. Carries a potential penalty of up to 3 years imprisonment, making it a felony. However, in practice, it's often applied to more direct or clearly obstructive conduct and typically after interference has crossed a certain substantial threshold. It does not always provide a clear, narrowly tailored mechanism to address crowd-based interference before it escalates into physical confrontation or an attempt to disarm an officer. I'll go even further with that. In Chittenden County, generally, if we charge impeding, it will charge it, personally arrested. Generally, it will be thrown out because it's felt that it is not quite there. So that's an issue we see a lot. So I don't believe that impeding is going to fall in a lot of these categories that we need it to fall into, whereas this actually does. So it defines boundaries around interference with first responders and active scenes, classifying violations as a misdemeanor, creates a proportional and enforceable deterrent. Gives officers and prosecutors an additional practical tool to intervene earlier before a volatile situation turns into an assault, a weapon grab, or a deadly force encounter. This is not about expanding authority without limits. It's about providing clarity and a measured response in circumstances that are increasingly common. I'll go back to what the representative said earlier when he was talking about his beginning of his career. The first time I had to push a crowd back was, I think, 3 weeks into my field training process. So I had the academy, which is a 4-month process. I entered field training and immediately was doing this stuff. And then it just goes and goes and goes. And we did it every weekend till I stepped off patrol working evening shift. And it doesn't just occur at night. That's just the majority of my career initially was worked at night on patrol. We do it during the daytime. We do it during like domestic disturbances and all types of situations like that. If there's a group of people that are around you while you're trying to effect an arrest, generally they get involved in some way, shape, or form, whether that's just trying to figure out what's going on or it's a little more volatile than that. What I like about this bill is it applies to.
I think I have a question.
Oh, yeah, sorry.
I just want to pick up on that. These aren't isolated incidences. These are things that happen all the time.
Yes, this is not like we deal with this once in a while, especially in Burlington in the last 5 years. These are very, very common. I've been dealing with them through my entire career. And like I said earlier, we had a better ability to deal with it. But I also picture, I represent 322 members across the state, not just in Burlington. I know in other towns, when you have 2 or 3 police officers working and 2 are called to the scene and all of a sudden there's a crowd and they're also trying to arrest somebody, you have nobody to come and step in and separate. It is you, that other officer, to handle all of that at one time. But like I said, as this bill applies to first responders more broadly, which is what I like, because the same challenges arise for firefighters and paramedics. Burlington Fire Department, people that I work with every single day, constantly, we show up on scenes. They call us all the time to come to scenes to help them with this all the time. I can't tell you how many times I've ran lights and sirens to a call from the fire department because they are dealing with a crowd that's getting unruly, or while they're dealing with the person they're trying to give care to, somebody else is trying to interject and they aren't listening to the firefighter or the paramedic to back up.
Oh, so it's actually like disruptive to like EMTs and fire engaging with medical services on the spot.
Yes. Like I said, we routinely see this. It's just rendering care and then there's interference going on. This gives that deterrence and it gives that authority to that firefighter to be like, or paramedic to be like, I need you to back up. You're violating this law. Please back up. So on and so forth. They give that clear command, and then we can do what we need to do if it's necessary. Hopefully we don't have to use this that much. Hopefully this law comes out and it's clearly laid out. And those that see it are like, all right, well, I know where I can be and where I can't be. I think that's also important, is knowing where that line is. And people don't sometimes know where that line is, or if there is a line at all. So they kind of try to interject in places they probably shouldn't. So last year, I'll give you a more recent one, and there's been stuff since, but this one sticks out to me because it almost ended incredibly, incredibly bad. We had 2 officers attempt to detain an individual in the alleyway between Church Street and City Hall Park. So there's a small alleyway there. During the incident, a large crowd formed and began trying to pull the officers away from the suspect. While this is happening, both officers are actively preventing the individual that they're dealing with, who they are attempting to detain, from retrieving a firearm from his waistband, which he is actively trying to get. And at one point, he has his hands on the firearm, and the officers are peeling his fingers back from the firearm, and they're fighting back and forth over this firearm. While this crowd is continually coming in and getting right on top of them. That could have gone a lot of different ways. And thankfully, those 2 officers were able to get control and prevent him from accessing the firearm. And thankfully, they didn't have to go to lethal force, but they were this close. This close. There was, could have gone either way at any point in time. But like I said before, these aren't unique to Burlington. This is happening across Vermont. And it especially happens in smaller agencies because they have less officers to do anything with that. I think going back to when you were talking about public safety emergency and all that, I think it's important that we think of a definition that, like, that definition is good. I actually like that definition. I think the actual definition pretty well lays it out, but a different word instead of public safety emergency could just be call for service, because that's what this is. These are calls for service, whether it's an initiated call for service, proactive, or you're responding to a call for service. That is what we are dealing with on a daily basis, and that's what this would really encompass. So that would be one recommendation I'd have for that. I think this represents a measured and practical addition to existing law. It reinforces clear boundaries at active emergency scenes, support accountability through proportionate consequences, helps reduce the likelihood that routine enforcement actions escalate into serious or deadly outcomes. I can't say that it's going to stop it, because we all know it. You know, we live in a volatile world and things happen and we can't stop everything, but this will give a clear deterrence, and it gives clear guidelines to people when they're actually on these scenes. I don't foresee this ever being used. I won't say ever. I don't see this being used in a situation where there's reporters coming in and videoing. They're very good at understanding to give us space to work. There are people that generally will, not so much First Amendment auditors, but there are people that will come in and we had one group was Burlington Cop Watch, and they would get a little too close at times, but usually they would listen when we would tell them to back up. A couple did not, and we dealt with that as it came. But that's the only time I really see this law applying to somebody recording us. We're recording ourselves the entire time with our Axons and with our dash cams. We expect to be recorded on top of that. That's not a hindrance as long as we have the space to do our job. And I'm not concerned about that person or those people interfering and impeding our ability to do that job.
Yeah, no, I think it's safe to say that, like, media professionals, broadly speaking, understand what you're trying to go through and where these sort of like boundaries of space for safety exist. Yes. Correct, that's no.
What was the word terminology you just said? Emergency safety call, safety
Call for service.
call for service?
Yeah, generally that's what we call anything that we go to a call for service.
Brett Morgan.
Yeah, just listening to all this and reading the book, I've read the bill fully and I'm in support of it. Also a selectman in my town, so I deal with our police force through our town manager. And in my district, I also talk with the sheriff's department in Major County that I represent. And what you all are expected to do on top of your jobs of trying to protect yourselves while doing that, I have a great appreciation for. And I think a lot of it does that part on people's First Amendment rights versus being able to get your job done and be done safely and be able to go home to your family at the end of the night. And similar to like we're seeing on the news, it's been in the last couple of days down in New York City, pieces of ice, snow dropped on it, snowballs thrown at police officers. That's lawlessness. And this, I think, will help protect some of that. And I think it's needed because you already have a tough job and be able to having to play, pardon the expression, with traffic cop in addition to dealing with the imminent situation. I have a great appreciation for it. So I think this is good. I like it. Thank you.
Any other questions for the detective? Thank you so much for your time, sir.
Thank you very much.
Anything else we folks? Well, we got 3 more minutes. No, okay.
Some question. Why would you not want it to take effect till January of 2027 when most stuff passes like July 1? I'm just wondering why it's being passed off till next January.
I can't answer that. I missed that.
Say July 1 or whatever.
Thanks for bringing
Or
it up.
upon passage.
Yeah, we see that a lot. Yeah.
So, before we wrap, speaking of this, and the reason I wanted to schedule this in conjunction with the previous testimony on the emergency response public safety bill that we're working, I wanted to hear this testimony, do the run through the witnesses, to consider that for possible inclusion in our bigger bill. So that was the reason that it dovetailed off of that previous testimony. Rep. Coffin.
I do like in this that it's going through chapter 13 or VSA, 13 VSA. The fines and penalties in this are not nearly as steep as a lot of the laws that are on the books right now for interfering with, hindering, obstruction. Some of those carry between 3 years to $500, 2 years to $500. When it's a lesser penalty, which it's still, there's a penalty, but it's not locking you up for up to 3 years, 2 years, based on
Yeah.
what else you could be charged with instead.
Mhm.
But it still offers the first responders some protection from harassment.
Rep. Hango.
I just want to bring up quickly, because there was a question, Florida's HALO law is somewhat similar to this, including the mandatory 25-foot buffer zone. And it includes all first responders. So you can take a look at that.
Anything else before we break for lunch? Nope. All right. Thank you, everyone. We will be back at 1 p.m. for more work on H67, our legislative operations and government accountability.